So FlySafair is facing an investigation by the National Consumer Commission into allegations of overbooking and overselling flights. This comes after concerns in the media, including social media platforms, from consumers complaining about the overbooking. The Consumer Commission says they initiated an investigation into the conduct of the airline to assess and review the compliance with provisions of the Consumer Protection Act 68 of 2008. Let's now bring in the head of complaints and investigations at the National Consumer Commission, Prudence Moilwa. Prudence, a very good morning to you. Thank you so much for making time for us. So how did you guys initiate this investigation? Was it on your own accord on the basis of the reports that you've been seeing and complaints on social media, or were there complaints that came directly to the Commission?
No. Good morning to your viewers. Yes, we initiated this complaint after we noted through the public discourse around the issue on the social media. And I think it's very important to note that the Commission has a mandate to monitor the market, the consumer markets. If and when we pick up an issue, we have an obligation to then initiate an investigation if we think there is a reasonable suspicion of contravention of the Consumer Protection Act.
Yeah, and we are actually showing that the tweet as well as FlySafair's response to it. I'm just quickly going to read what Tato had to say. So he says that, so we show up at the airport and FlySafair says we don't have seats for the same flight we paid for. If you have 200 seats, why take payments for 300 passengers? And then FlySafair's, whoever's behind that particular account, then explains the reasoning behind it. But the Commission is saying that it's also going to look into this particular aspect and their rationale behind it, looking at what Section 47 of the Consumer Protection Act says.
Yes, that's correct. Because there are modalities that are considered. Obviously, when you look at the provisions of Section 47, it does say that overbooking, when done where it is out of the control of the supplier, is one consideration. The other is on when it says that where it is anticipated by the consumer in terms of the agreement, then there might be that overbooking can be allowed. But also when you look at the provisions of Section 47, it does say that under those circumstances, the level of redress, information provided to the consumer, as well as how the supplier addresses the inconveniences suffered, is one of the aspects that we will want to look at through this investigation to see whether or not, as they implement the overbooking, if and when they do, is it within their control, number one? Number two, have they brought this to the attention of consumers as they book the flights? Number two. And another aspect is just the redress around it. Basically, what we are hoping for is for the airline industry, through this investigation of FlySafair, to just look at their practices and their consciousness towards consumer protection when they deal with consumers. So that's one of the aspects that we want to address, and also just for the industry as a whole to just have the consciousness of consumer protection provisions and how they protect consumers as they use their services.
Yeah, and that Section 47 does make provision for certain defences that can be used by, in this particular case, the service provider being FlySafair. But I want to go to subsection 5B. The supplier took reasonable steps to inform the consumer of shortages of stock or capacity as soon as it was practically possible to do so in the circumstances. In this particular case, Tato says that we arrived and we show up at the airport. Would that be considered reasonable if I'm only informed once I get to the airport about to board my flight that actually you have been bumped off?
Yes, and that's precisely why we want to do this investigation, to get to the bottom of this. If and when we find out that there are policies as well as terms and conditions around this, how they are brought to the attention of the consumer. And number one. Number two, another aspect, especially on the terms and conditions and policies, they still have to be fair terms and conditions in terms of other provisions of the Consumer Protection Act. And if in any way there are terms and conditions or policies that might affect consumers negatively, they need to be brought to the attention of the consumers. Suppliers are duty-bound to make consumers aware, to draw the attention of the consumers to those policies. But like I've already said, it is not just those policies that we'll be looking at, it's just how they are implemented in order to make sure that consumer harm is not perpetuated. Because we do view this as a very serious possible violation of the Consumer Protection Act, because looking at the fact that consumer circumstances are different and the losses that might come about as a result of this type of practices, is one of the things that we want to look at as well. So we want the engagement. We've already sent a set of questionnaires to FlySafair. We've given them 14 days to respond. And we want to look at all these aspects of overbooking, the issue of the no-shows as well, how they manage the two, if they want to use that as a defense or as reasons why they overbook. We want to see how it is implemented so that consumer harm is not perpetuated.
Yeah, and this is an aspect that I actually raised with one of the aviation experts, Mr. Dr. Guy Leach, and his argument was that overbooking is already covered. There is provision for overbooking, as we've just had this conversation now. But the argument also that it's not uncommon for overbooking to happen in the aviation sector. It is something that is a global norm. Is that a defense enough to say that, but this is what happens in the aviation sector globally, nothing new to South Africa?
Yeah, I think it's one of the things that when we highlighted this investigation, we said the industry will have to take a look at how they apply the policies. We might note that it might be an international practice, but it has to be balanced against the consumer rights as well. Because in the Act, even when you look at the provisions for certain expected things to happen in various industries, you still need to make sure that even as you provide the redress or how you approach your policies, you still are aware of the rights of consumers that are being trampled. Consumers in South Africa are fully protected in terms of the Consumer Protection Act. So it cannot just be taken to say that it is globally, the practice. You still need to put in measures in place, number one, to bring those policies and terms and conditions to the attention of the consumer, and to make sure that if and when you do overbook, you provide consumers with information, number one. Number two, to also make sure that you give them appropriate redress, not just a refund, but to also address the issues of inconveniences. So it can't just be a blanket approach. Each transaction has to be considered on its own merits. So, for example, if you look at some of the issues that have been brought up by the consumers in terms of inconveniences, we can't just say that, well, because it's a known practice, they can just continue acting like it is business as usual when we have provisions of the Consumer Protection Act that also, deals with those aspects of saying how you do it also is regulated.
Yeah, and again, just referring to that conversation that I had with Dr. Guy Leach, the other part that he emphasizes on is that, unfortunately, unlike with the United States and European nations, airline passengers don't enjoy as much protection as we see in those two countries, even when it comes to, for instance, the undue delay that would happen. If you and I miss the flight, or if you and I arrive late for check-in, that means that you missed the flight and it's the end of the story. But the airline is allowed to arrive late at the airport, inconveniencing you as a passenger, and beyond that, you don't have any recourse. All you're going to get is an apology.
Yeah, that's the level of unconscionability that we would like to deal with. And that is why I'm saying, generally, the industry will have to now be alive to the fact that the law requires of them to be conscious of the rights of consumers as well. And the fact that consumers in South Africa are not protected is not true. The consumer protection is fully in force, and it provides for protection for South African consumers. Hence our approach to the FlySafair investigation, to say that the rest of the industry will also have to take heart of the things that will be coming up now, and also look at improving consumer protection within industry.
Yeah, and now, considering that you're saying that this is an opportunity for the aviation industry also to deal with some of these aspects in relation to their passengers and consumers, and how you protect those consumers and the type of service that you are providing. Would you be inviting the Civil Aviation Authority? Would you be having a conversation with them at all to speak about what has happened in this particular instance? And are you also saying that you are opening this process to other airlines as well, if indeed they want to make any contribution to this investigation?
For sure, as much information is required as possible. And like you say, that they are bringing in aspects of international practices. This is some of the things that will be open to listening to balance it also against the issues of consumer protection. We also are saying to consumers who have complaints against other airlines to please contact the National Consumer Commission, so that we also look at the veracity of the issue within the industry. So we might be having this investigation against FlySafair, but it is not just focused on FlySafair. We're saying other industry players must watch the space, participate, and also take meetings with the Commission, associations as well. But we also want to say other airlines who are doing the same thing would like to also invite consumers to lodge complaints with the National Consumer Commission.
Okay. Do you have any turnaround time in terms of deadline to deal with this investigation? I know you said that you'd given FlySafair 14 days to respond to the set of questions.
Yes. As I indicated earlier, we've given them 14 days, but also with the in-depth information that we're looking for, that we still need to ask further information on, and we've also required them to submit quite substantive amount of information, that if they require an extension, we will be duty-bound to give it to them. And also other aspects will require for us to look at international practices as well, as you indicate, and also look at the responses that come through. But we want to finalize this within 3 months, which might not necessarily be possible, but that is our goal. Our turnaround time would be to finalize this in the next 3 months.
Yeah. And what are the possible penalties for contravention of the Consumer Protection Act?
Okay, in terms of the Consumer Protection Act, there's 3 aspects following the outcome of an investigation. The first one, we can enter into a settlement, which is a consent agreement that may be, done into an order of the tribunal, wherein we can then agree either on a penalty as well as for them to admit the wrongs and how they will rectify them. The second one, the Commission, after finding out that there is prohibited conduct, is duty-bound to also approach the National Consumer Tribunal for an appropriate fine. The Act talks about 10% of the annual turnover, as well as or 1 million rand, or whichever would be the appropriate fine in that regard. Another one would be the issuance of a compliance notice, wherein we put them on terms with regard to how they should comply with the Act.
Prudence, thank you so much for your time. Prudence Moilwa is the Head of Complaints and Investigations at the National Consumer Commission.